Debt recovery. In this short video we will look at the process by which a business recovers money from a person who owes them a debt. The first step in recovering a debt is to issue a letter of demand. Now this is a letter by the business to the debtor setting out very clearly why the debtor owes them money, how much money they owe, and what will happen if the debtor does not pay the debt. So in the example letter of demand on the screen, we can see that the letter is divided up into a number of paragraphs. The first paragraph sets out the background. I am writing in relation to our outstanding invoice dated 1 January 2008 in the amount of $1,000. A copy of the invoice is enclosed. The second paragraph sets out what the problem is. Payment of our invoice was required by no later than 15 January, but to date payment has not been received. The third paragraph sets out the actual demand, what it is that the business wants the other person to do. Please make payment in full by no later than 5 p.m. on Friday, 22 January. You can pay the invoice by depositing the money directly into our bank account. The account details are on the invoice. And the fourth paragraph sets out the consequences of not complying with the demand. In the event that we do not receive payment in full by that date, we will be instructing our solicitors to promptly commence legal proceedings to recover the outstanding amount. I hope that such action will not be necessary. This is a fairly standard format for a letter of demand. One paragraph setting out the background, one paragraph setting out what the problem is, one paragraph setting out what needs to be done, and the final paragraph setting out the consequences of not doing it. A letter of demand will often be successful in prompting the debtor to pay the outstanding amount, but if it is not successful, then before actually moving on to litigation, it's often a good idea to explore alternative forms of dispute resolution. Litigation can be both stressful and destructive, and so instead the dispute may be resolved using mediation or arbitration or even simply negotiation directly by the parties in order to avoid having to go to court. But if alternative dispute resolution is not successful, then it will be necessary to commence litigation against the debtor in order to recover the money. The first step in the litigation process is the preparation by the business, or rather its lawyers, of a statement of claim. So the statement of claim sets out the details of the creditor's claim and identifies them as the plaintiff and the debtor as the defendant. A copy of the statement of claim is lodged in the court registry to formally notify the court that proceedings have commenced, and a copy of the statement of claim is then served upon the debtor. And by service we mean that the statement of claim is formally delivered to the debtor in a way that can be later proven in court. The debtor has a number of different possible responses available to them, so they may admit liability and offer to repay the debt, at which stage the dispute will be over, or the debtor can deny liability and seek to rely upon some form of defense. They may insist, for example, that they do not in fact owe the money, or they may insist that the creditor themselves owes the debtor money, which can be offset against the money owed by the debtor back to the creditor, or they may have some other legitimate reason for refusing to pay the debt. If they do seek to rely upon a defense, then they will lodge a defense with the court registry and deliver a copy to the plaintiff. Of course, the third option is for the debtor to simply ignore the statement of claim, but as we'll see in a moment, this has quite serious consequences for the debtor. If the debtor has denied liability, the matter will proceed to a trial. Each side will present their side of the argument, supported by witnesses and other evidence, and the court will make a decision about the debtor's liability. If the debtor has failed to respond to the statement of claim, then the creditor, the business, will be entitled to apply to the court for default judgment. This means that because the debtor has actually failed to lodge a defense or to respond in any way to the statement of claim, the court will automatically decide the issue in favor of the business. So, assuming that the court has in fact ordered the debtor to pay the debt to the business, and if the debtor then continues to refuse to pay, then there are a number of ways in which the business can enforce the court's judgment. If the business was a secured creditor, then they are entitled to, of course, seize the goods, or foreclose, or exercise their power of sale over the property that was the subject of the security. Another option is a writ of execution. This is an order of the court directing an officer of the court to enforce the judgment by seizing the debtor's property, auctioning it, and using the proceeds to repay the debt. A third option is a garnishee order. This is an order of the court directing a third party who owes money to the debtor to pay that money directly to the creditor. So, for example, the business may seek a garnishee order that is addressed to the debtor's employer, ordering the employer to pay a portion of the debtor's wages directly to the business. And if none of those options are successful, or they are for some reason unavailable, then the business may have to resort to actually bankrupting the debtor if they're an individual, or if the debtor is a company, putting the company into liquidation. We will look at bankruptcy and liquidation and the alternatives to both in the next video.